two Americans seriously injured in last year's White Island eruption have officially filed lawsuits against White Island Tours and the Royal Caribbean Cruise Line. Matt and Lauren Uri were in New Zealand on their honeymoon and visited the island as part of a package with the cruise line. Both were seriously injured in the eruption that killed 21 people and injured a further 26. They're seeking damages from both the cruise line that sold them the tour and the tour operators. So, how can lawsuits like this be filed outside of New Zealand, given our own laws are vastly different from that in the United States? And we all know how ACC works. To talk us through the lawsuits, we're joined by Matt and Lauren's lawyer, Michael Winkelman, who is beaming in from Colorado. Michael, thanks so much for being with us. We really appreciate your time. Can I just ask you what Matt and Lauren knew about Whakaari White Island when they were going there? What had they been told about the risk?
Nothing. And if your viewers wanted to take a look at the complaint, they could find it online. And it actually has the brochure that Royal Caribbean offered to them. And all it says is that an active volcano. And while I'm sure some of your viewers might say, well, wait a minute, it's an active volcano, that means there's a risk. What they didn't tell them, and what Royal Caribbean had a duty to tell them, John, was that there was this heightened risk in the weeks leading up to it. They raised it from that level 1 to that level 2, and there was all this chatter talking about it was going to be similar volcanic activity to that period of 2011 to 2016 when there were 3 eruptions. So the short answer to your question is, John, they knew really nothing other than that it was an active volcano.
So your case against Royal Caribbean, or Caribbean as you say in the States, is that they had a duty to inform, a duty of care that they didn't honour.
That's 100% correct. As it relates to Royal Caribbean, they have a crystal clear duty to warn. So when there was that heightened risk level of volcanic activity, they had a duty to warn Matt and Lauren and all those other passengers on that ship about an increased risk that faced them. As it relates to the shore excursion company, it's a question of whether or not they should have canceled the tour as a whole, which is a separate issue from whether or not Royal Caribbean had a duty to warn.
And let's talk about White Island Tours. And look, everyone watching and you know the ACC regime in New Zealand and how that works and what it precludes. How can you take this case in the context of New Zealand law?
So it's actually very simple, John, and we do it all the time. So I'm based in Miami, Florida, USA, which is the cruise ship capital of the world. They sell hundreds of millions of shore excursions every single year. That's all the cruise lines. So all the time we have people that get hurt on shore excursions, could be in the Caribbean, could be in New Zealand, could be in Japan. We still sue in Miami, and which you're required to do against the cruise line. And we say that essentially the laws that apply to the cruise line should apply to the ticket, the person who sold the excursion as well. Notably, I haven't seen the contract between White Island and Royal Caribbean, but every other contract that I've ever seen actually calls for the application of Florida law. So there's a very significant chance that all of that really draconian New Zealand law won't even apply, it will be irrelevant. So the goal for the folks, whether they're from Australia or New Zealand, for the Americans, it's much easier, but for the folks in your neck of the woods, there's a chance they can avoid the reach of the very draconian laws of New Zealand.
I think we're somewhat more affectionate about it than the use of the word draconian, but I'll let that rest. So what, in terms of your ability to sue White Island Tours, does that extend entirely to the contract between Royal Caribbean and White Island Tours?
At this point, yes. I mean, to my knowledge, there were 38 cruise ship passengers that were hurt, 19 of them killed. I know there were a couple guides that were killed. What I'm referring to really, I need that nexus related to the cruise line. Because it's a cruise line. Right.
Yeah, okay. Where did Matt and Lauren buy their tickets for the...
At home in Virginia, which is a state in the United States. When they were planning their cruise, they went online and looked at the shore excursion brochure from Royal Caribbean.
Okay, so that too was going to be part of your case in terms of that recusing you from New Zealand law?
Correct. I think it all stems from the fact that there's this relationship between Royal Caribbean, based in Miami, and this New Zealand-based company, that they're selling and marketing and advertising these tours to folks in the United States. That is one of the arguments that I think leans towards the application of U.S. law as opposed to New Zealand law.
You specialise in this kind of work. Have you ever won a case like this, given similar jurisdictional issues?
So the short answer is yes. We've been successful in a number of these cases, really dozens of cases. Keep in mind, we've been doing this since the 1970s. Having said that, the law is not very favorable. It's very difficult to keep jurisdiction or a court to have power over a foreign defendant in the U.S. Having said that, we do it all the time. It's one of the things that we really take a lot of pride in. We're the ones that are pushing to keep the law as favorable as it is. So It's a unique case.
Yep.
It's really something that's unprecedented in a lot of ways. But I think there's a lot of facts that are very favorable for being able to keep U.S. law applicable over the New Zealand tour.
Michael, I've had the wine, but I want to ask you a question. Morally, how do we get this right? New Zealand is arguably one of the adventure tourism capitals of the world, right? And a lot of people come here to have adventures like going up volcanoes and bungee jumping and, you know, high-risk activities. How do we act in a way that leaves us clear of accusations that we were complacent or nonchalant or glib?
It's a great question, and I think I'm one of the perfect people to answer because all I do for a living is personal injury lawsuits, essentially on the sea, so when people get hurt. And I think the first step, and I think there could be many steps, but the first step is making sure the passenger or the customer is fully informed. I think if they had put a piece of paper in front of Matt Lawrence saying, hey, this is what GeoNet said, this is the increased risk, it's similar to a pattern from before, and you fully inform them of the risk, A, I know they never would have been on that excursion, but B, then I think you have a much better argument that everyone in New Zealand is doing more to educate the consumer. Having said that, there's a lot of adrenaline and junkies out there that they're not going to care what the risk is and they're going to do it anyway. So,
Michael Winkelman, thank you so much for joining us, Michael. We really appreciate your time this morning. It was a fascinating conversation.
My
Thanks,
pleasure.
Michael. Thank you.